bring him out. Pretty good.
Good morning, County Mayor Michael Lopez. This is our case number 24FM7529. The court earlier swore out a 12-count complaint against Mr. Lopez from the testimony of the detective in charge. We have a prosecutor present in the courtroom. The defendant is present in custody by Zoom. His court-appointed attorney for today is also present by Zoom. We'll proceed with an arraignment today. If I could have an appearance from the prosecutor, please.
Good morning, Your Honor, to your staff. Ron Henry on behalf of the people, P62243.
Thank you. Mr. Haynes, your appearance, please.
Thank you, Good morning, Mr. Court, Michael Lopez. Going forward, he is court.
I've already signed the court-appointed attorney paperwork. After today's arraignment, the county will assign an attorney for the next proceedings. Mr. Lopez, please state your name. Can we cut down on some background noise?
I think that's in the jail.
Nope. Yeah, whatever you got there, close the doors. If we could proceed with this. I'm prepared to advise the defendant of the counts against him, the penalties and his rights. Anything preliminary to that the attorney will address?
Your Honor, who would like to address bond when appropriate?
All right, we'll go through the counts first. Mr. Lopez, please pay attention. As to count one, it's alleged that on July 21, 2024, you did murder. Mohammed Saeed, peace officer who was lawfully engaged in the performance of his duties, and you did so knowing that he was an officer engaged in the performance of his duties as an officer. Do you understand that charge against you? You understand you're being charged with murder of a peace officer?
Yes.
The penalty is life without parole. Do you understand the penalty?
Yes.
It's alleged that on that date in the city of Melvindale, you were in possession of a firearm when you were ineligible to possess such a firearm because you had a felony record. Do you understand that charge?
Yes.
That's typically a 5-year felony. You are being prosecuted as an habitual offender, and the possible punishment is enhanced to 15 years in prison. Do you understand that possible?
Yes.
Count 3, it's alleged you possess ammunition on that date and location when prohibited. Do you understand that charge?
Yes.
It's also a 5-year felony enhanced to 15 years in prison because of your record. Do you understand that?
Yes.
Count 4, you're charged with carrying a concealed weapon on that date and location. Do you understand that charge?
Yes.
It's also a 5-year felony enhanced to 15 years because of your record. You do understand that?
Yes.
Count 5, you're charged with knowingly or intentionally possessing methamphetamine. Do you understand that charge?
I guess, yes.
They allegedly found it in your bag, which included items of identification. You do understand that charge? And the drugs were field tested. Do you understand that charge?
Yes.
That's a 10-year felony enhanced to life in prison because of your record. Do you understand the penalty?
Yes.
Count 6, you're charged with possession of cocaine. Do you understand that charge?
Yes.
That's That's a 4-year felony enhanced to 15 years in prison because of your record. Do you understand that penalty?
Yes.
Count 7, you're charged with possession of a dangerous weapon being carried with unlawful intent. That has to do with the knife that was found on your person at the time of your arrest. Do you understand that charge?
Yes.
That's a 5-year felony enhanced to 15 years because of your record. Do you understand that penalty?
Yes.
And Mr. Haynes and Mr. Lopez, counts 8 through 12 are felony firearm charges that go along with these other charges. These are 2-year felonies enhanced to 15 years in prison. Do you understand that, Mr. Lopez?
Yes.
You have a right to remain silent. Anything you say orally or in writing can be used against you in court. You have a right to an attorney for this proceeding. You've been assigned an attorney through this court. For your next proceedings, you'll be assigned an attorney through the county. In the district court, you have rights to 2 hearings called the probable cause conference and the preliminary exam. A probable cause conference is a hearing where your attorney can meet with the prosecutor to discuss issues in the case moving forward. A preliminary exam is a hearing where the prosecutor would have the burden of establishing what the probable cause standard of the crime was committed and then who committed the crime. You generally have the right to have that hearing conducted within 21 days from today. However, those dates may be changing. I'll go on the record on that a little further. We are going to set a PCC date of August 12th at 9 o'clock. Do you understand all those rights, Mr. Lopez?
Yes.
All right. Let me hear from the prosecutor as to bond, please.
Thank you, Your Honor. While the court indicated the charges that the defendant is facing, the highest being murder of a police officer, given that charge, MCR 6.106 indicates in part that remand is appropriate when someone is charged with that offense. But in addition to that, committing 2 prior violent offenses within the last 15 years also suffices for remand. The defendant has prior convictions for carjacking, resisting and obstructing a police officer causing injury, and resisting and obstructing a police officer as well. 2 of the priors that I indicated occurred in 2012. Arising out of that incident, he was also charged with disarming a police officer, fleeing and eluding third. In addition to that, in Taylor District Court, he was charged with carjacking in 2012. He was not convicted of those offenses, but those arise out of those incidences. In 2023, in Oakland County Circuit Court, he was convicted of resisting and obstructing a police officer as well. He has several prior police contacts. He went to prison for the carjacking offense, was released about 2 years ago. When he was placed on parole, he absconded parole, violated parole, did not comply with any of the requirements. He was suspected of a criminal sexual conduct case arising also out of Oakland County. He was ultimately discharged from parole after he served his sentence with regards to the resisting and obstructing in Oakland County, and that discharge occurred about a month ago from parole. Now, given the heinousness of this offense, given that he had a gun when he was a felon and prohibited from doing so, given that he had guns, a gun, drugs, that he was arrested with a knife when he, after the murder of police officer Said, he's made admissions to the murder. He's also made admissions to an armed robbery arising out of an incident that happened the day before the homicide of the officer on July the 20th of 2024 in Lincoln Park at an AutoZone. He was charged with that offense, was arraigned on that offense this morning as well. He's a threat to society. He's a threat to the public. The likelihood of conviction is high, and his bond should be set at remand. Thank you.
Thank you. Mr. Haynes, do you wish to address bond?
I think the points have to go, whether it's remand or whether there's a high cash bond. Mr. Lopez is not going to make bond. So, we just wanted, speedy proceeding. And the complete sentence compensated August 12th is acceptable. So we don't know other comment.
All right. The 8th Amendment indicates no excessive bail is allowed. However, in the course of our history, it's been determined that in some cases, no bail should be allowed, as the prosecutor points to Michigan Court 6.106 specifically addresses situations like this. My 20 years on the bench, I haven't seen a case that is more deserving of no bond, so the defendant is remanded without bond. Moving forward, this court is going to disqualify itself from this case. I thought it was important to handle the case today. The defendant has certain speedy trial rights. The nature of the proceedings today, I think, allowed me to proceed today, both in swearing out the complaint, handling the arraignment, and setting bond. But both Judge Courtwright and I are going to disqualify ourselves. We have the paperwork ready to go. We're going to submit it to the state today. We should know by Monday or Tuesday which court this will be going to and which when the next dates will be set. The defendant generally has a right to have that exam within 21 days. I'm making a finding of good cause at this time that 21 day rule may need to be exceeded because of the complications that, in this case, involve sending it to the state and all the discovery materials that need to be shared with the defendant's attorney. I'll note for the record, our staff is present. We had a moment of silence the other day for Corporal Saeed. We consider him part of the court family. We'll all be going to services today, and we're rearranging our schedule for tomorrow, so we have a skeleton crew here to handle court operations, but we'll be attending services tomorrow. With all that, it's not appropriate that we continue to handle this case. I'd ask the media, I know there's a lot of public concern, I'd ask the public and the media to refrain from contacting us for at least a couple days while we go through these services. We should know something next week, and we'll reach out, or you can reach out to us next week, and we'll give you more information on where the case is heading. Anything else for today from the prosecutor?
No, Your Honor.
Mr. Haynes, anything else?
No, Your Honor.
All right, that concludes the hearing. Thank you.
Thank you guys for stopping by. This is just the beginning of this, an arraignment, read his charges. Some people excuse themselves, and we'll follow this case and see what happens. See you in the next one.